All right. Good morning, everyone. Thank you for hopping on to this month's Industry 30. I'm pleased to introduce today's speaker, Andrew MacDonald, who's chapter legal counsel and attorney with Fox Rothschild. Today's seminar is going to be a legal update with Andrew. In the meantime, this webinar is being recorded and will be put on the chapter's website so you can reference it at a later time. If you do have any questions mid-presentation, please use the chat feature, and at the end, there'll be a time for questions. With that being said, I'm going to turn it over to Andrew. Thank you.
Thank you very much, Rob. As Rob said, my name is Andrew MacDonald. I'm a partner at Fox Rothschild in Philadelphia. Advise the chapter on various legal issues, mainly labor and employment law. Today's presentation is going to be focused on labor and employment law, and we will go through some very, very recent updates. And I think it's good to put it out in the open up front. One of the main goals, one of the main takeaways that I would want you to have from this presentation is that a lot of things are unclear, up in the air, subject to change. And so that is always a good thing to stay advised, but keep your ears and eyes out for any updates that may happen. And you'll see why specifically pretty quickly in this presentation. So I'm going to share my screen here. All right. So here are our topics for today. The topics for today are going to involve two specific things and then a more general topic. So the first thing that I'm going to talk about is a salary threshold overtime rule. I'll explain a little more what that means and why it really doesn't matter anymore. But you may have seen some guidance from the chapter, from NECA National, about this Department of Labor regulation. The next thing is a Federal Trade Commission rule on non-competes. This is was past tense, was a rule, another topic of updates from the chapter and from NECA National that also is not going into effect. And it's a pretty good segue to talk about what some of the possible changes or maybe lack of change or just complete lack of clarity of what we have with the new incoming administration starting in mid-January. So as my title here says, is that the update is no update. You don't have to do anything with regard to this rule. It is no longer in effect. But the Department of Labor last year issued a regulation that would have raised the minimum threshold for someone to be a salaried exempt employee. So mainly think office workers, people not bargaining unit employees, no one doing manual labor. These are not hourly employees. So generally office administration functions. By January 1st, if this rule was in effect, and to be clear, it's not going to be in effect, I'll explain a little later why, you would have had to at least pay that person $58,656 a year, and that would have had an escalator every 3 years. It would have went up per inflation every 3 years. And that was going to cause a dramatic change. There are many people who right now make under $58,656 per year that are salaried employees. They're not hourly employees. They are someone who makes the same amount of money regardless of how many hours they work in a work week, whether that's 30, 40, 50, 60, there's no overtime. So there would have been a pretty large change in terms of whether you're going to convert that person to hourly or are you going to give that person a raise if they were making less than that amount. Now, the July 1st increase from 35,000 to 43,000 did go into effect because I'll jump to the next slide now. On November 15th, a federal court in Texas issued an injunction against this rule. So even though in July and up to November 14th, early in the morning of November 15th, that regulation was in effect, it is no longer in effect. So employers now, if you gave someone a raise because of the July 1st increase, you legally don't have to have that increase anymore. Now, that's a judgment call, a practical issue about decreasing someone's salary or converting them back to hourly or doing reversing whatever change you want to do. But legally, the number, going back to the last slide, the minimum is $35,598, $684 a week for the salary threshold. So this was a change that has been retroactively reversed. Not something that we like to see as employment lawyers. I'm sure not something that you as a business owner or executive manager want to see in your business. But that is how it has happened. And we can expect some more of these issues where there's a regulation, a rule, a regulation, a law, something to plan for, possibly put into effect, and then a court say, no, that never should have happened in the first place. You may think of something like the vaccine mandate, which was around for a while, you prepared for, and then it went away because the Supreme Court said so. So this injunction, it could in the future be dissolved by an appeals court or the Supreme Court, or it could stay in place. It's something that you're going to have to stay in tune. So, I might give another presentation in 6 or 8 months or a year that says, update is that it's all back in effect. Hopefully not retroactively, because that would be a big mess. But there is a lot of uncertainty here in the legal world about whether any laws, regulations, rules are going to be reversed by a court, which is almost always in Texas. That's not a legal issue. That's just a practical issue of Texas judges being conservative and being ready to issue nationwide injunctions against government rules. So a very, very similar issue was a Federal Trade Commission rule, a regulation that was issued back in April. It was supposed to go into effect on September 4th. It would have essentially prohibited non-compete agreements. So that's an agreement that an employer and an employee have that after their employment ends, they will not work at all for a competitor. There are other types of agreements you've probably heard of: non-solicitation, confidentiality agreements. Those were not subject to that rule. An important distinction is a non-solicitation would be you employee would agree not to contact customers of an employer after their employment ends, which is a specific act, versus non-compete is broader. It is just won't work for a competitor. So under a non-solicitation, you could work for a competitor, but as long as you don't solicit customers of the old employer. So important distinction there, just to be clear. But as the next slide says, another Texas federal court issued a nationwide injunction halting this rule. Just like I said before, an appeals court could overturn that ruling, or the Supreme Court could put it back into effect. But this one never went into effect There's nothing that you have to do about it. But it's just another example here of a regulation that you would need to prepare for. I mentioned that this rule is supposed to go into effect on September 4th. August 20th, the court issued the nationwide injunction. So not much time between when that ruling was issued and the injunction and when the regulation was supposed to go into effect, when the ruling was issued. So it's very important, especially if you have any issue, talk to experienced counsel in this area. You could do a Google search and you could think that there's a nationwide non-compete ban because that article is pre-August 20th. If in the future this nationwide injunction is dissolved by an appeals court, you could read something on Google that says that it's been enjoined, it's been halted. So you really need to make sure that you have updated current information. You really should talk with your business's counsel, lawyer, get good counsel on any of these issues that are political and legal issues. So anything that is changing the employment on a broad term, broad scope across the nation is going to become a political issue. Some group is going to try to get an injunction, and you could see this go either way, but it's usually a Democratic initiative to raise the minimum wage, raise the salary threshold, ban non-competes, and it's usually halted by a conservative court. But you could see things go the other way, although it might affect your business some other way, not employment related. So it's very important to have updated current news, seek counsel, don't rely on things that you may read that may not be true anymore online. Now that I mentioned non-competes, I do want to make it very clear that the rule was a rule that would have banned, prohibited almost every non-compete across the country. There were exceptions for senior executives, and that was really geared to very senior executives that had operational directional control over either a large department or the entire business, not just someone who's a supervisor or a manager. That rule has nothing to do with regular state law on non-compete agreements. So Pennsylvania, New Jersey, most states except for California use what's called a reasonableness test for non-competes. And most states will enforce a 2-year non-compete that is attached to your business in some way, whether that's a geographic restriction or a restriction on contacting customers or working with customers that the business had during its term. So got to be tied to your business interests. It's got to be limited in time. It can't be 20 years. It can't be 10 years. Usually 2 is the magic number, sometimes 3, sometimes more if it's related to a very senior executive or the sale of a business. And usually in terms of geography, unless you are a nationwide business. So if you do business nationwide, you could restrict someone nationwide. But if you only do work in Southeast Pennsylvania, that's the limit of your non-compete. Now, there are more and more state initiatives on non-competes, but we're not seeing anything in Pennsylvania. There's nothing specific in states like New Jersey, but there are states like Virginia, like Massachusetts, have limited non-competes to either specific people who aren't making a certain amount of money, or limited to 1 year or a lesser year than most courts would hold up. So I mentioned this more because we talked about non-competes, and it is not as if this Texas court injunction has prohibited non-competes nationwide or added some sort of nationwide limitation, you're still going to look to your state law, wherever the employee is, to see if that non-compete is going to be operative. And the same thing for the overtime rule. The Texas court has not prohibited overtime or made it so that people can work unlimited hours without overtime. The overtime rule is still in effect. Time and a half for hourly employees over 40 hours in a work week. And that threshold is still in effect at 35,000 for someone to be a salaried employee. The only thing that rule would have done would be to raise that threshold, and the court injunction just slapped it down, so it's back down to where it was. So in terms of new changes on the horizon, with the new administration and in states, what are we seeing? So nothing really in Pennsylvania. Pennsylvania has not had many employment laws in terms of compared to other states like New Jersey or New York. There's just not as many employment laws. There's divided government in the legislature. The Democrats in Pennsylvania kind of know that they're not going to get much passed. So there's not much action in Pennsylvania. There's plenty of action in New Jersey. There's been some new laws in Delaware. I mean, there are increasing state laws. States are not waiting on the federal government to take action on employment, and they're passing their own laws. Now, Philadelphia is somewhat of an exception. Also, Allegheny County out in Pittsburgh will pass some ordinances. Like Pennsylvania has a sick time ordinance where that doesn't apply outside of Philadelphia. So, but there's no specific action that we're seeing in Philadelphia. So I'm not sure if there'll be anything, but there could be. So it's something else to watch out for. Federal wise, we have a new administration. There's new policies. You could read whatever was put out on the campaign, but what the plan is very unclear. So I added a question mark there. We're not entirely sure what legislative developments, regulatory developments that we're going to see. Here are some observations, though. And it's important to distinguish something that the president can do on an executive order, Congress through legislation, or the executive branch by regulation. So executive orders can be signed, ripped up, a new one can be put into effect, however the president wants to do it. Now, there was an executive order on PLAs, which is relevant to this group. I imagine that incoming President Trump will probably rescind that order on PLAs for federal projects. So that's federal government, federal projects. So that can be instituted by an executive order, just an order from the president. In terms of legislation, the Republicans have control of Congress, but it's a thin majority in the House. There's just a lot going on. I'm not sure we're going to see much legislation on employment laws, labor laws coming out of the Congress. Regulation, so the president through the departments of government can issue regulations. It's slower, but it doesn't require Congress's action. So the regulation has to be put out. There has to be what's called a notice and comment period. And once that comment period ends, the administration can publish a regulation. Someone can go to court and challenge that regulation, which is what we saw in the first two examples on the slides here today. So there could be there's a greater ability for the executive branch to take action via regulation, but I'm not sure what we're going to see. The last Trump administration did raise the minimum wage threshold up to that 35,000. So that was challenged in court too. That was upheld though. So you might see something less incremental than what the Democrats had proposed last time around, but who knows? Another topic of note relevant to this group is infrastructure funds. The incoming president, Trump, had committed during the campaign to halt infrastructure funds that were already appropriated by Congress. But he's not supposed to be able to do that. If something uh, has been appropriated by Congress, it's supposed to be um, allocated and used up and sent to contractors to perform the work. There is a principle called impoundment, where the executive branch would just not spend that money, but that is a very controversial move. That would be subject to the courts. But as you're probably not surprised, there have also been talk from the campaign about when it was the campaign about allowing that infrastructure money to continue to be spent. Republican members of Congress would not be happy, even if they voted against it, for the infrastructure money that was slated for their district to not be spent. So there's a battle of interest there. I'm not sure what's going to happen, but that is a target, that could be a target. That infrastructure funds for projects, federal government projects, may be pulled back. But who knows? We'll have to just watch and see what happens. The Department of Labor, there's a very surprise choice for at least the nominee. She certainly has not been confirmed. She's a congresswoman, a former congresswoman from Oregon named Laurie Chavez de Reamer. I would describe her as a moderate / pro-union Republican. She is one of the 3 Republican congresspeople who supported and voted in favor of what was called the PRO Act, which was really a extremely pro-union bill, would have completely changed the National Labor Relations Act. Very pro-union bill. She sponsored it in Congress. She voted for it. Didn't go anywhere. It didn't pass through the Senate. But it's interesting. She is the daughter of a Teamster and made that part of her campaign. She apparently, per rumors, has the very strong support of the Teamsters president, Sean O'Brien. And the rumor is he whispered into Trump's ear, and that's how she got the nomination. Who knows if that's true? But if she is the Department of Labor secretary, those regulations issued by the Department of Labor, may not be your typical Republican regulations. Who knows? We'll have to watch. But she might want to raise that salary threshold high, like the Democrats. So who knows? Only time will tell. But that's interesting. Tea leaves here that we're getting out of the nominations. NLRB, National Labor Relations Board, I put that for the last here. I could talk on a whole presentation. I am actually talking for an entire hour just about the NLRB and the incoming possible changes next week. But here I just have no bullet points under it. It is something to watch. But for a group like yourself that has NECA as a bargaining representative, has long-standing, very good relations with IBEW folks, labor board rulings don't really affect you too much. It doesn't really matter if the NLRB allows employees to wear things wear union insignia at work, because, you guys have the stickers on your trucks and stickers on hard hats, and it's not a big issue. If the NLRB changes some sort of rule about protest activity, you deal with that regular, and that usually targeted to non-union folks. So changes in the labor board don't really affect longstanding building trades, good relationships with the unions. But, there could be some sort of development. We have no idea what's going to happen with the labor board. Last night, the chairwoman of the labor board's vote to reconfirm her was denied. So her term ends Monday. And starting Monday, the labor board will only have 3 out of 5 members in place. So 2 Democrats, 1 Republican. And we'll see what happens. The new administration could try to confirm all Republicans for the rest of the seats. It's unclear. We'll have to watch. But again, NLRB developments don't normally affect businesses like yourself. So I have 4 minutes left. Any questions for me while you have me?
Thank you, Andrew. If there are any questions, please unmute yourself, or you can shoot me a message in the chat. We'll leave it open for about a minute. Hearing none, really just want to thank you again, Andrew. I know the chapter has been sending out notifications on all these legal updates, and then had been rescinding them once they become invalid. But we try to keep our members up to date, and we'll continue to do that in the future. I just want to hope everybody has a great holiday season. This wraps up our Industry 30 for 2024, and we have another schedule of webinars in 2025. So with that being said, thank you everyone and have a great holiday.
Thank you, everyone. Happy holidays.
Thanks, you too.
Time.